Ladies and gentlemen, good morning, good afternoon, or good evening, depending on where you are joining us. Thanks for joining us the event today, organized by the Philip K.H. Wang Center for Chinese Law of the University of Hong Kong. The Center for Chinese Law was established in 2009 for the teaching, research, and promotion of Chinese law and China-related legal issues. This June, we are very fortunate to receive a very generous donation from the Philip K.H. Wang Foundation to support our Chinese Law Center. As such, the event today is the first public event after the naming of the Philip K.H. Wang Center for Chinese Law. So we are very pleased to present this event and also, of course, thank the donor for generous donation. Today, we are very fortunate to have Mr. Charles Mark as a speaker. Charles is currently visiting our Chinese Law Center under the Leslie Wright Fellowship Scheme. Charles is a PhD candidate in international law and a graduate teaching assistant at the University of Glasgow. He has close contacts with 3 local law schools in Hong Kong. After obtaining his LLB degree from the University of Sussex, he got 2 master's degrees from the CUHK and CTU. He is also the fellow of several institutions in the field of arbitration and dispute resolution. He is at the moment completing his doctoral thesis on sovereign debt restructuring. In the meantime, he has also published several articles in the field of dispute resolution. Today's talk is based on his co-authored article regarding online mediation. I have the privilege to know the 3 co-authors and have had a chance to read the draft article last year before its official publication. Thanks to the use of the internet, ODR emerged in the 1990s in the United States. So first appeared in the United States. However, it was not very successful in the first few years of its development. The COVID-19 provides an excellent opportunity to push the development of ODR in recent years. There are a lot of theoretical and practical discussions on the application and regulation of ODR. The scope of ODR is very broad. There are quite a lot of discussions. We do not really have a consensus yet. But in general, we believe that it is not only limited to online ADR, online arbitration, online negotiation, online mediation, but also it also covers online litigation, like the internet court that was set up in mainland China. Charles focused his study in today's talk basically to online mediation, which of course is a very important area. The study of online mediation is much needed. I still remember a lot of discussion has been carried out regarding the application of online mediation in various fields. In particular, we talk about the family disputes. As I just mentioned, that ODR emerged first in the United States, but later on, China has seen them develop so quickly, in particular in the last 1 decade. Thus, a comparative study of online mediation in China and the United States would be most meaningful. Dear participants, we will also, after the presentation, after the talk, we will also reserve some time for Q&A. So if you have any questions, please put in the chat box. I will read out the questions when we move to the Q&A session. Or I'm not too sure whether you can speak out, but I think to ensure the order of the talk, I think probably you can put in the chat box for me to read out, to pose a question to the speaker. So without further ado, I will now pass the floor to Charles. The topic of the talk today is how the COVID-19 pandemic has influenced the growth and regulation of online mediation in China and the United States. Charles, please, you have the floor.
Thank you. So can you see my slides? Yes, okay. Professor Shao, thank you very much for your kind introduction. Good afternoon, everyone. Thank you for registering for my talk. I'm very excited to present my work on the development and regulation of online mediation in China and the United States under the COVID-19 pandemic today. So this talk is based on a paper co-authored by me with Professor Carrie, Shang and Dr. Wenli that's published in the World Arbitrations and Mediation Reviewed previously. So the recent COVID-19 crisis has such a stage for a significant increase in the use of online dispute resolution. Under the worldwide country lockdown and social distancing orders, behaviors of people have adjusted drastically. So since the pandemic has expanded the uses of online technology in areas such as medicine and distance learning, online dispute resolution has received unprecedented interest and attention in different jurisdictions. In recent years, there is a trend that online mediation become one of the major forms of online dispute resolution mechanisms used by parties to resolve disputes. So with the surge of interest in online mediations across jurisdictions, it is particularly interesting in exploring two different development paths of online mediations post-COVID-19 in China and the United States, the world's two largest economies, in details. In the following sections, I will investigate two different development paths of online mediation in post-COVID-19 era taken in China and the United States. So before we get into the discussions, I will briefly talk about what is online dispute resolution, ODR. ODR, in its broadest definitions, refers to the coupling of technology with alternative dispute resolution, ADR. It has been a growing force in the ADR movement for several decades. Compared with the offline world, cyberspace is much more self-contained and self-governed space, posing stronger barriers for any external regulator to enter. Idealists and optimists of the internet usually believe that it is possible for online dispute be completely resolved online. Further, their belief is only bolstered during the times of a global pandemic such as COVID-19. So the primary aims of my talk today is to forecast the full trajectory of online dispute resolution development in the post-COVID-19 world and understand any prefixed approach and preference in dispute resolution discourses that overly bolstering state-led or private interest-driven initiative. So in recent years, some of the most aggressive and notable developments of ODR-connected public justice systems have taken places in People's Republic of China. Online conflict resolution systems were first adopted by e-commerce platforms to resolve small volume disputes between online sellers and shoppers. Before long, the Chinese government started to invest enormous resources in its court to explore how ODR technologies could be applied in the judiciary, forming the basis of smart court construction campaigns. By the end of 2019, China established three internet courts in Hangzhou, Beijing, and Guangzhou, which has handled around 1.2 million disputes since its initial operations. So, although the transition to online court has already become a national policy priority, the outbreak of COVID-19 had brought unprecedented opportunities for ODR in China, especially online mediation. The COVID-19 pandemic occurred earlier in China, followed by a lockdown order of the virus epicenter in Wuhan on February 5, 2020. Thereafter, the entire country went into a strict lockdown status during the most of the February. Differencing from social distancing measures, the strict quarantine and physical isolation measures have rendered contract-based or face-to-face dispute resolution impossible. On February 18, 2020, China's Supreme People's Court, the SPC, issued a notice of strengthening and standardizing online litigation during the prevention and control of novel coronavirus epidemic. So it was referred to notice, mandating that all court levels in China actively test the use of online dispute resolution, establish the online mediation platform, and ensure the availability and quality of ADR measures. The notice vastly sped up the development of online mediations during February 2020. Specifically, three significant improvements are highlighted here. First, the expanded scope of ODR. Second, the increased participation of private online mediation providers, leading to a more fierce market competition. And third, the stronger push towards the national-wide online mediation regulatory scheme. So, I'm going to talk about the impact of the post-COVID-19 measures. The first, regarding the expanded scope of ODR, the Zhejiang High People's Court, which was the first court in China to adopt a court-annexed ODR platform, continues its lead in promoting the use of online mediation. In addition to having launched 7 specialized online mediation platforms covering property, financial, and online lending disputes, it further expanded the scope of services to areas where online mediation was less frequently used, such as administrative disputes and environmental disputes. As the only specialized financial court in the country, the Shanghai Financial Court also strengthened its online mediation platform during the pandemic. Further, the court took the lead in launching a coordinated pre-trial ADR platform between its online mediation portal and a private mediation network. The Securities and Futures Dispute Online Resolution Platform of Investor China. This ADR platform facilitates complex financial disputes to be resolved in a more efficient and convenient manner by developing a sharing network of mediators with financial expertise. Government agencies such as China Securities Regulatory Commissions and the China Banking Regulatory Commissions have taken similar measures have issued regulations to perfect the online dispute resolution mechanism for disputes between consumers and financial institutions under their supervision. Due to the impact of those measures, the use of online mediation platforms during the pandemic has increased rapidly. According to the data from the Information Center of the SPC, from February 3rd to March 13, 2020, Chinese courts of all levels have conducted nearly 152,379 pre-trial online mediations. Further, from January 23rd to March 13th, 2020, the number of the new user visits to the Zhejiang ODR platform reached 249,901. So with 20,795 newly registered users, Chinese authorities also reported a high settlement rate of these online mediated cases. For example, Tianjin People's Court boasted a settlement rate of 91.67% within the time frame provided by its online mediation proceedings. Based on the official data provided by the SPC, the numbers of the online mediation cases during the pandemic increased by 89.1% compared to the same period of 2019. Concerning the increased participation of private online mediation providers, leading to a more fierce market competitions, in addition to court-annexed ODR platforms in China, privately owned and operated online mediation organizations have also attracted more users during the pandemic. The surge in demand for online mediation called for more participation for private service provider. To address this surge, market-based online mediation organizations were quickly being established in Shanghai, Xiamen, Hangzhou, and other places in China. As a private sector leader of ODR service platforms, Beiming Software Co. Limited launched its online mediation platform, Dispute Resolution Cloud. It also allied with the Hong Kong Mediation Center to launch the first cross-border online mediation forum, the International Dispute Resolution and Risk Management Institute, which has initially attracted 25 users to register. Interestingly, the surge of the private online mediation providers has also allowed for development for profit mediation services, China traditionally distinguished between court-annexed mediation and extrajudicial mediation, which is usually conducted in a community-based manner. The 2010 People's Mediation Law legalized and formalized community-based mediation to resolve disputes among people in a timely manner and maintain the harmony and order of the society. Within the scope of the People's Mediation Law, community-based mediation is offered for free by qualified community mediators. These mediators are appointed by the local and community level, the People's Mediation Committee. Before the pandemic, SPC supported the development of commercial mediation organizations, industry mediations organizations, and mediation conducted by licensed legal professionals. However, largely preoccupied with the conception that mediation service should be provided free of charge, Chinese society has not quickly adjusted to for-profit mediations. On October 29, 2019, Shanghai authorities classify that mediation service providers can charge a fee at least 12 different types of dispute. These include trade, finance, logistics, insurance, real estate, and property rights dispute. Still, it has not until the outbreak of the pandemic that big numbers of mediation service providers gradually began to practice and promote commercializations of private mediation services. A couple of cities, including Hangzhou, soon followed Shanghai's lead by encouraging that the market should continue to cultivate and strengthening dispute resolution mechanism represented by lawyers, setting the stage for a large wave of private mediation organizations to be formed. This is likely to create a mediation service market in China, which will modernize and transform the mediation markets to be more in line with international standards of practice. As regards to the strong push towards a nationwide online mediation regulatory scheme, currently ODR is probably the only type of ADR that is still not centrally regulated in China. Lacking centralized regulations can operate as a curse because without a strong guarantee from state authorities, there has been lack of trust and confidence in online mediation proceedings. Most private ODR service providers have also not established procedural rules for online mediation. In addition, some of them have no clear provisions concerning the platforms, fees schedules, procedural rules, and code of conduct for neutrals. These all have somewhat restrained the development of ODR in China. According to Chinese tradition, the perception of institutional authority is directly linked to the perception of justice. Under the same tokens, the movement towards the regulation of online mediations is a symbol of authoritative credibility. Under the impetus of the pandemic, China's online mediation rules have gradually been standardized as reflected in the online mediation procedural rules and the ethical guidelines governing mediators. On March 9, 2020, the China Council for the Promotion of International Trade Business Community and its affiliated mediation center jointly released the Commercial Mediation Service Specialization Consultation Draft for public consultation and will begin research on further improvements in the standardizations of online mediation in China. The Zhejiang Higher's People's Court has also prioritized the standardizations of online mediation procedures. Also, Chinese dispute resolution scholars have gradually deepened their research on rules and standards governing online mediation. The Chinese Academy of Social Sciences has launched a national emergency social science grant to fund research project on this area, focusing on the standardization of online mediation procedures as a means to strengthen procedural justice in China. So, however, one current weaknesses of the online mediation in China is lack of qualified mediation professionals. Court-annexed mediation still comprises a majority of online mediation conducted in China during the pandemic. These online mediation programs transform the roles of judges in courtrooms. The court needs to adopt a far more proactive role by collectively fulfilling the functions of conflict analysis, prevention, mitigation, and resolution. Judges, accordingly, will act as overseers rather than decision makers. In turn, people will more frequently turn to the court as a coordination of resolution options and less frequently as the adjudicator of justice. By the same token, the court will potentially evolve into a settlement arena rather than a forum of adjudications. However, the majority of Chinese judges are unprepared for these changing dimensions of justice. There is a lack of judicial talent who have mastered internet technologies and have demonstrated a high level of digital literacy. This also holds true for private mediators, possibly based on the Chinese perceptions of mediations as a community-based, free of charge, and informal. Qualified legal professionals in China tends to avoid practicing in mediations for far more lucrative areas. To attract more qualified legal professionals to practice in mediation as a way to improving the professionalizations, in 2017, the Supreme People's Court of China and the PRC Ministry of Justice passed the opinions of implementing the pilot program of lawyers' mediations. This made lawyers participating in mediations as one of the central objectives of recent ADR reform. This pilot program was first conducted in 11 economically advanced regions in China. The opinions mandated that qualified local people's court and lawyers associations need to establish specialized lawyer mediator studios as places to organize and designate legal professionals, particularly lawyers, to mediate cases referred by the court. Lawyers who participate in mediations are usually compensated for their services. In 2019, the applicable scope of the opinions was further expanded to all provinces of China. To improve the professional ability of mediators during the pandemic, Chinese court has both strengthened and the quality of and organized more training courses for mediators. For example, the Zhejiang High People's Court organized a live broadcast lesson within its jurisdiction to standardize online mediation procedures. The Guangzhou Internet Court has also utilized the cloud classroom to organize online live mediation rules analyzed, which has attracted more than 30,000 participants. The Shenzhen Intermediate People's Court launched a Blue Ocean School program to organize a series of online courses on commercial mediations at 8 p.m., which received a high numbers of viewers. Further, other courts, such as the Tianjin, Hainan, Inner Mongolia, Hebei, Zhengzhou, has also carried out a variety of online mediation-related training courses. Likewise, the Shanghai Financial Mediation Center and other relevant institutions has provided similar virtual mediation training courses, which have received welcoming responses. The courses improved the professional capacity of mediators and enhanced the credibility of online mediations. They have also changed the mindset of Chinese public, making more members of society willing to try ODR measures. State propaganda like these enhance the fields of overall status by signaling to the public that online mediation is both respectable and trustworthy. Although it is a bit early to make a certain predictions, it is likely professional lawyers' mediations will experience growth after the pandemic. So, in the US, the applications of traditional mediation practice in an online environment has already received a great deal of attention before the outbreak of COVID-19 pandemic. The American Bar Association, the ABA, model standards of the conduct for mediators recognize the ideas of party autonomy and self-determination as a central foundation of the mediation process. Even before the COVID-19 pandemic, online mediations was already used by companies to resolve high volume and long distance disputes. For example, eBay, a pioneer of the consumer ODR, began allowing its consumer to resolve their disputes online through a third-party dispute resolution providers, Square Trade, since early 2000s. It has recorded by prominent mediators in the field. Singular instance of mediation conducted by the remote communications tools occurred back in the 1980s. Further, during the 2000s, law and ADR journals published articles focusing on the applications of technologies to mediations. Initial discussions of mediation range from conducting wholly online mediation process to hybrid process that use online communication tools as means of interactions distinct from primary face-to-face proceedings, to applications of some online technologies to facilitate traditional face-to-face process. So, during the COVID-19 pandemic, social distancing and stay-at-home orders throughout the country, it revived the interest of wholly integrated online mediation proceedings. Moreover, there are more personalized technology designs and attempts to make online meetings as more effective and efficient as face-to-face. Similar to China, the United States also experienced a surge of supply and demand of online mediation that would venues during the pandemic. This effort is primarily driven by the groups of concerned members of the mediator community. Mediations and arbitration institutions and professional organizations such as the International Council of Online Dispute Resolution, the National Center for State Court, and the ABA. Different from China, a significant amount of focus has placed on improving technological competence of mediators and data security. This might eventually lead to an emerge of a more self-determined and tightly self-regulated ODR profession. As the demand of online mediation surged, one of the earliest issues raised was the technical competence of American mediators. Around early March 2020, prominent national mediation service providers such as JAMS, JAMS, and the International Institution for Conflict Prevention and Resolution started to train their neutrals and advocates to on topic of how to use professional online meeting platforms such as Zoom that we're using, life-size or other high-quality video conferencing systems. Smaller and more regional private mediation groups also provide the necessary tools to deal with the increasing needs for mediators and parties to conduct meetings online. For example, Matthew Prevalent, founders of the Florida mediation group, iMediate Inc., stated in an interview that in response to the spread of COVID-19, iMediate, the company, promised to work with our clients to address this growing public health crisis in a smart, strategic, and serious manner. Their unique video conferencing platform known as the iChat, which utilized the Cisco's WebEx communications platform, already successfully provided online mediation services for commercial and family matter a few years back. Therefore, it has a special edge during the periods like these. On the other hand, technology companies specialize in providing either video conferencing service or building online chat functions such as the Slack.com, Discord.com, Rocket Chat, and other companies like that have caught the attention of the field. Some of these platforms started to aggressively promote their service as a discounted price, hoping to gain more active users during the pandemic who will stay with their service for a long time. Regarding the ethical compliance, before the pandemic, the ABA had already begun to recognize that the importance of having technological competent lawyers in the changing legal arena. In the ABA's 2012 revised model rules of professional responsibility, the ABA revised and the definition of lawyers' competence to include some forms of technological survey. However, as suggested by Greenberg and Norm in a 2019 paper, the rules wording is broad and subject to interpretations. Further, the rule has failed to spark widespread interest in advancing lawyers' technological competence. It is likely to be impacted by the pandemic, as many mediators have moved to either voluntarily or involuntarily upgrade their technological skills to better serve the changing needs of clients. This change of mindset could lead professional regulators to raise the bar of technological competence. Confidentiality is another important pillar of mediation proceedings conducted in the US. Security is of paramount importance of successful conduct of online mediation proceedings due to the various similarities with the online environment. At a minimum, dispute resolution professionals must ensure disruptions that conversation have an online individual. Courses are indeed private. Working with the International Council on Commercial Arbitrations and the New York Bar Association, the CPR an institution has also just launched cybersecurity protocol. This protocol provides a framework to determine reasonable information and data security measures to be implemented in online setting. Further, the protocol's intent is to increase the community awareness about security risks in general. Some of the most silent controversies during the pandemic involved the use of Zoom, a popular online video conferencing tool that went to a high of 10 million users per day to a daily average of 200 million users in March 2020 overnight. After the skyrocketing of newly registered users, Zoom also enjoyed a high record on Nasdaq per share since February 2020, while the S&P 500 lost nearly 30% due to the lockdown during exactly the same period. However, myriad of the security issues also immediately aroused as Zoom gained more publicity and popularity. These issues range from Zoom booming to illegal recording to unauthorized sharing of its users' data with Facebook to backing up some of the data in China. The Citizen Lab, an interdisciplinary laboratory based in the University of Toronto's Monk School of Global Affairs and Public Policy, released a report discouraging the use of Zoom during the time for cases that require strong privacy and confidentiality as a result of those troubling security issues. The report has spurred a series of anti-Zoom response in the field based on the serious suspicions of Zoom's capacities in properly handling users' security and privacy concerns. Two class actions lawsuits were quickly filed against Zoom based on Zoom's violation of relevance data regulations, one of which was initiated by its shareholders. At the same time, many US educational institutions and public authorities were advised to ban the use of Zoom and the use of more creditable or safe platforms. Despite these controversies, Zoom still has some defenders in the ADR field. Some mediators have mentioned that Zoom has a better accessibility features and enables access to virtually impaired mediation participants. For example, Rich Wenli, one of the Canada's foremost mediators, point out that although Zoom is not perfect, it is safe enough to use in the vast majority of commercial mediations. Many have pointed out that the majority of these data safety issues surrounding Zoom are not Zoom issues, but rather they're caused by the improper user habit and or user mistakes. Others have also mentioned that Zoom is generally easier to use and to gain the level of expertise needed for conducting mediation sessions successfully. Zoom's building breakout room features which gives many mediators the familiarity of a caucus section, also sustains students' popularity in the mediation field. Therefore, even as data safety inquiries surrounding Zoom increases, it will probably dominate in the US online mediation market as good technological tools, balancing the accessibility and the feasibility needs of mediation in climate crisis. During the pandemic, the use of technology and social distancing will drive immense changes in the mediation professions. The change of professional preferences and the client preferences will eventually work to impact the disputing parties' preferences. Since fast and responsive changes of ODR are most initiated by the self-help tools and self-coordinated efforts, will these changes spur the eventual emergence of stronger ODR professions? For advocates of ODR professionalizations, creating an atmosphere in which parties trust their mediators and increasingly also for another party consider vital, if not indispensable. For the effectiveness of most out-of-court dispute resolution mechanisms, but creating such an atmosphere has been proven difficult in online setting. The suggestions that every online dispute resolver must follow a professional code and clearly stated which code is being followed before the parties agree to proceed the process has become difficult to fulfill. Therefore, although the diverse self-regulatory initiatives dominate the field of ODR, there has been lack of comprehensive and profession-wide regulation in place. This is less likely to change immediately post-pandemic, but the pandemic itself might have presented some opportunities for the entire profession to strive for a higher quality of self-regulating governance standards and market practices. As a predominant and quality standard-setting organizations in the field of ODR, International Council for Online Dispute Resolution quickly promulgated its video mediation guidelines and video arbitration guidelines. These guidelines lay out 5 basic principles of virtual mediations and or arbitrations, focusing providing accessible, competent, confident, impartial, and secure service online. These principles lay the foundation for more dialogues towards a more widely agreed upon professional standard. However, in US history, there has always been some suspicions and distrust of externally imposed measures of institutionalizations of both ADR proceedings and anti-professionalization of various local mediation communities built upon a continuation of liberalist thought. Unless the field as a whole seeks to greater external engagements that could increase the ODR adoptions and institutionalizations, any emergence of professional standards leading to a better credibility of the entire professions, even during the pandemic, will come from the inside the community. So when comparing with the US and China approaches in a global pandemic, in the contemporary jurisprudence, the categorizations of ODR methods as private and informal has rooted in the traditions of common law. Such categorization, which places mediations, negotiations, and arbitrations in the opposite side of dispute resolution spectrum, as litigation, distinguish disputes that are resolved privately and informally from those that implicated public values. In the US, the rise of ADR date back to Professor Frank Sanders' multi-door courthouse approach. Under this approach, ADR was community response to emergent problems in formal adjudication in 1970s and moved access to justice beyond a court-centric approach. Since the beginning, the US ADR reflected a common ideology in its emphasis on individual needs, comprised interest, and mutual understanding, rather than determining parties' legal entitlements or rights in procedurally safeguarded way. This emphasis has also been extended to ODL, a field dominated by ADL professionals recognizing the needs and potential of this field to embrace advanced technology through self-embraced effort. Accordingly, in the US, the ODL community took the lead in responding to changing behaviors and needs in the dispute resolution field under pressures of a global public health emergency. The pandemic has motivated professional associations and professionals themselves to arrange online workshops and webinars, share useful resources and best practice, and spread news of upgrading knowledge and skill sets to adjust technological advancements in the field. This bottom-up initiative developed community-based response hold a strong promise of strengthening self-regulations and self-governance in the field. In China's state-led economy, however, the state must act faster to provide sufficient mandate and guidelines to incentivize the use of ODL in court and private sectors. The SPC's February notice constituted a good gesture of the central judiciary. Unfortunately, as discussed, in the few years leading to pandemic, the country has already begun a national campaign towards the construction of smart courts. This campaign upgraded internet infrastructure and enabled all levels of court fully move their dispute resolution process online. Therefore, it is well equipped and adapt to the changing dynamic of the field in China. Rooted in a Confucian thought, the development of contemporary mediation in China has never fully disposed of its public function. Over the past 30 years, China has seen substantial legal developments giving rise to a tenfold increase in the numbers of cases handled by the court system in the 2010s. And this phenomenon is similar to the litigation explosion in the United States. At the same time, there was also an increasing number of disputes between citizens and the state, as well as among private parties. These developments led to a party state to reconsider dispute resolution reform policy, and revival of mediations was perceived as necessary to provide a means through which some of the harsher collateral consequences of rapid economic growth could be aired and redressed. Therefore, the function of social governance is always an inseparable goal of mediation in China that is not observed in most Western nations, including the US. This dimension was also evidenced during the pandemic. In an official report, the SPC emphasized that online mediations has become an effective means to ease the pressures on trials and in these special periods, which has in various ways strengthened the pre-trial governance function of the court. The emphasis put on online mediations also serves to create a method of dispute resolution that is more consistent with the public options, minimizing the dissatisfactions and more transparency. So, however, a top-down approach towards mediations does not in any way suggest that it slows the development. China's court-centric measures in recent years have gained both growth numbers of litigants and mediated cases, enable stronger social and judicial governance. The Chinese state and the society approaches of the pandemic with a more holistic and integrated approach, seeing the halting of further spread of virus in the country as a key to the Chinese people continue the pursuit of economic progress and social safeguard. Under such a narrative, achieving a satisfactory outlined outcome of anti-virus battle has been symbolized as a victory of China's governance system. Further, the reliance on online mediations to maintain a harmonious social order is an essential part of the country's top policy agenda. The emergence of stronger market-based online mediation practices during the pandemic is more of a byproduct rather than an outcome of changing dispute resolution needs, and will eventually be embedded in the discourse surrounding the concurrence of virus. Overall, compared to a more gradual and self-initiated approach emphasizing client needs, China, the centrally planned approach could have some significant drawbacks. Because the state's overall visions concerning online mediations is well designed and catch-all solution to the social problems, more than a simple interest-based dispute settlement tool. Important principle of ADR can sometimes be identified. One such principle is that information and data safety. Currently, many types of dispute prevention technologies developed by Chinese ODR firms rely on the collection, analysis, sharing of a large amount of dispute data, which brings to light hidden dangers to information security. These ODR technologies often require an extensive collections of user information and litigations-related data. For instance, the SPC 2019 Chinese Court and Internet Judiciary White Paper provide that an intelligence service platform built by Xinjiang Intermediate People's Court collect litigants' address information with mobile phones, numbers, active address of civil activists, address registered with the government agency and successful service records in court. However, it never explained why such information is needed for dispute prevention and predictive models for decision making. In the absence of an explanation, there are gaps in the potential for inquiries of information safety. Protecting the safety of information during the ODR process results in a disciplining of justice provided in China. On May 28, 2019, the PRC National Internet Information Office published a measures of data security management, which is a draft for comment, the measures, which set forth more stringent requirements for data collections, use, supervision, and management. Although data security law, the measures focus more on the use and collection of data and information rather than directly tackling external risk, such as hacks and cyber attacks. Nevertheless, many provisions of the measures are still vague and lack of means of enforcement. On December 30, 2019, the Chinese Ministry of Industry and Information Technology further promulgated a new regulation of guidelines on determining illegal and illicit collection of use of private information by apps, which elevated the standard of collecting personal information through the use of commercial applications. Although the regulations applies to the illicit and illegal collections of personal information, which should include ODR apps, it is unclear whether how the government entirely apps are bound by the regulations. An additional guide to the construction of network data security standard system was added to the pilot of Ministry of Industry and Information Technology and published for public consultation during the COVID-19 pandemic. This guide sought to formulate more uniform standard for personal data compliance. However, considering the extremely sensitive issues of government infringement on individual privacy in China, limiting any forms of government power, including government ability to collect private information, is rather challenging. This has become an issue of tracing and surveillance apps used during the pandemic became a routine part of Chinese government's tracking of its citizens when it relaxed lockdown measures. Concerns arise about whether these temporary measures will become a permanent fixture of posing more serious issues to personal privacy and information safety in China. So, in conclusion, even though some of the current use of ODR has accelerated more out of necessity than desire, developments in each of the two jurisdictions examined in the talk today have brought about relatively successful pluralist accounts. These developments, both top-down and bottom-up, support an approach to dispute resolution that acknowledge the need for a balance between formal and informal process that is currently presented by the market and the state. These trends speak against any prefix approach and preference in dispute resolution initiative that overall favor formal and informal law. In relation to general questions of what type of pathway is most likely to promote quicker response to the sudden pandemic outbreak, US experience and to a lesser extent Chinese experience suggests that no major distinctions should be drawn between state-mandated or community-based methodology. Overall, the situation in China is much more complicated and volatile, with time and the socio-economic challenge that swing mediation as a means of resolving social disputes and conflict in a time of tension. It should not be surprising that China will soon become the leader of ODR with the massive number of cases resolved through online mediation. At the same time, there is a plenty of evidence that as demonstrated by the movements during the pandemic that ADR, such as mediation, has the same, if not more capacity in addressing societal concerns of a fast evolving emergency. Those active in the field of dispute resolution, both in China and the United States, are becoming impressively conversant with many of the ODR's subtle upsides and downsides with over time. Such growing level of familiarity and sophistications are impressive, representing strong endeavors and the mobilization powers of members of the ODR community. So that is the end of my presentation. Thank you very much.
Thank you, Charles, for your enlightening talk. I can see that we still have around 8 minutes for Q&A. I must say ODR is now a very hot topic. Charles, you mentioned about the operation, regulation, etc. I think regulatory regime is no doubt one major issue that has been discussed. At the international level, which we can see is that the effort has been made by several very important international organizations, including the UNCITRAL, HCCH, and APEC, etc. But today, I think you talk about the regulations at the national level. So you describe two different approaches or pathways in the two jurisdictions, which is, I think, is very illuminating. Before I move to the Q&A questions raised in the Q&A function, I have one comment. Probably you can also have some response on that. When you examine the Chinese situation, you actually look at more on the judicial mediation. Because the documents that you have mentioned are all issued by Supreme People's Court. But you know, I think in mainland China, the judge indeed can take up the mediation work, right? But in the United States, the judge normally will channel the mediation to a third neutral party, a mediation center like the James, etc. So the judge themselves will not take up the job of mediation. So in a way, we can find out that in China, there's a need for the Supreme People's Court to issue some guidelines, some documents regarding the judge's role as a mediator. But for the United States, normally we have to rely upon the work of the mediators. That's why we can see a lot of commercial arbitration or mediation centers. They issue the documents regarding the mediators' ethical rule, etc. Now, in China, if you move out of the internet court or Supreme People's Court documents, actually, we can also see a lot of developments that were made by the CTEC, by Guangzhou Arbitration Commission, or you mentioned about the 2009-2010 in Shanghai, that's the Shanghai Commercial Mediation Center. They also issue quite a lot of documents, ethical rules, etc., on how to use the internet to facilitate the own mediation or arbitration services. I think probably in China, you need to, I think probably can have a full picture because China advocates the grand mediation scheme. Apart from judicial mediation, we also have a people's mediation, administrative mediation, commercial mediation, etc. So quite a lot of issues are coming up. So that's my concern. I think whether that really gives us the full picture about online mediation in mainland China.
I think further research needs to be conducted since my research paper is not comprehensive enough to include the private sector. So I think I need to do more research on that. Thank you so much. Your comment is really useful, really helpful. Thank you.
Yeah, thank you. Thank you. I can see that there are some questions here. Grace Ip, I think from the DOJ, has asked one question regarding the use of the online mediation to resolve ISDS disputes, investor-state dispute settlement, and whether there's a need to or possibility to include a mediation clause as a precondition for other ADR processes, which I assume I think is under discussion by the third working group of the anti-trial now. Possibly you can very
definitely.
Yeah.
I think definitely. I think there should be inserting a mediation clause as an immediate precondition for other ADR process in treaty-making mechanism, especially for ODR, not only online mediations, but also online adjudications, online mediation, online arbitration, etc. I think especially mediation as well. So yeah, definitely.
Yes, I think I also agree with your views, I think, regarding the online mediation. Yes. The next question mentions about the blockchain technology, whether developments in blockchain technology foster further development of ODR in relation to encryption and confidentiality, etc.
Totally. I think blockchain technologies just grow really fast right now. I think in this area, there will be many opportunities for ODR practitioners to further develop some more tailor-made tools for online mediation. Yes.
I think probably we also can note about the new developments of the EBRAM in Hong Kong, which also
Yes.
studying about the incorporation of blockchain technologies in its own platform, which also includes a study of a smart contract, how to facilitate the dispute resolution processes. So I think that one.
Yes.
Here we have the last question by the Dean of the Law Faculty, Professor Fu Hualing. He asked, would the online mediation favor pass or be downgraded once the pandemic is over? Are there other motivating factors to sustain online mediation? Are there more structural changes in support of the mediation and online mediation?
I think the world has changed after the pandemic. So I think online mediations is favored past once the pandemic is over. And I think there are other motivating factors to sustain online mediations. For example, the blockchain technologies and the technologies. And I think in the future, there will be more appropriate appropriate program, appropriate platform. In fact, the Beiming Software Limited, I just mentioned, the Chinese very prominent, very popular platform. They have to do many work in developing tools and forum for online mediation. So I think in the future, there must be the online mediation favor past after the pandemic. And there are some more structural changes in support mediation, online mediation in China in the future. I think, yeah, there must be some more state-mandated measures on online mediation in China in the future.
Yeah, thank you, Charles. Yeah, I think that's. Oh, sorry, I jump in. Anything to add? Sorry. Okay. Yeah, so thank you, Charles, I think, for your answer. I also noticed that actually when you discuss about the regime in the United States or probably in China, there are quite a lot of discussions regarding the self-regulation for the ODR. That means we need to leave the internet industry, but the pure self-regulation is not the ideal. This needs to be supported by the government or some international governmental organizations. So that's why I think they're also looking to the future. Once the pandemic is over, how to make the ODR, including online mediation, more sustainable. So I think that's an effort that have been carried out by the international organizations. Like the anti-trial is not very successful in 2016. And then APEC has been rather successful in a way in adopting some rules. Guangzhou Arbitration Commission has already added or acceded to the framework. So I think all these efforts, I think definitely will be able to help the ODR or online mediation more sustainable.
Yes.
I can see there are still two questions. Very briefly, I think probably I could put these two questions together. You can briefly respond to two questions. Why is it in the United States that the people considered out-of-court dispute resolution? And next one, how about the application of AI in ODR services?
I'm not sure about the first question. Why is that people consider out-of-court dispute resolution But I can answer the second question. I think in the future, AI is definitely, they can like act as a secretary, not as a mediator. So actually in arbitrations, there is a tribunal secretary for arbitrators. And I think I have argued in other blog posts that in mediations, we should also have mediator assistants, like similar to tribunal secretary. But I think the role of mediation assistants could be by AI, like scheduling for check the conflict of interest for the mediators, check the schedule, book the room. I think AI can do it in the future.
Yeah, thank you, Charles. I think regarding the first question, probably I think this has something to do with access to justice movement in the United States. There are two rounds of the movement. The second round, I think we can find out that's something to do with the access using of the ADR, alternative dispute resolution. So out of court dispute resolution, which can bring in the access to justice. Apart from the first round regarding the class actions, etc., and legal aid. So I think this could probably has something to do with this kind of movement in the 1970s or 80s. Then afterwards, of course, we can see latest developments regarding the use of ODR starting from 1990s in the academic institutions. So I think that probably something that I understand. So I think that's all I can see, and I can see the time is almost up. So before closing, I would like to thank Charles for the excellent talk and look forward to further discussions with you in the future. I would also like to thank the participants for joining this event. I think look forward to your participation in the events organized by the Philip K.H. Wong Center for Chinese Law in the future. So thank you, and the event is closed. Thank you very much.